On March 15, 2026, in the Criminal Court of Tennessee's 23rd Judicial District, defendant Jonathan Krantz appeared before the court for a bond revocation hearing on charges of aggravated domestic assault. The 28-year-old defendant, already facing serious felony charges from a September 2024 incident involving an AR-15-style weapon, and his ex-girlfriend, now stands accused of violating his bond conditions through non-payment of GPS monitoring fees and new criminal charges. What began as a domestic violence case has escalated into a complex legal proceeding examining whether Krantz deserves to remain free pending trial or return to custody.
I believe, yes, ma'am.
Is this the only one that you think doesn't require you to go back to jail?
What do you mean? I didn't say anything doesn't require me to go back to jail.
What kind of things did you agree to when you made bond? What kind of behaviors and things did you agree to when you made bond?
Don't go anywhere that she may be.
Okay.
And I was not told where it is and went back to jail because of it. And then no illegal activity, I think, or whatever. Just don't contact her.
Okay. And other things like, appear for court.
There was a page. Yes, ma'am. There was a page.
There's a whole page of different things.
All that stuff was stolen. I don't know. It was all thrown in the dumpster.
Is this the only time you've ever made bond before in your life?
For this amount of time, yes, ma'am.
Okay. Have you ever had to go back for violating a bond condition before?
Yes, ma'am.
Okay,
Yes,
so you understand if you violate a bond condition, you go back to jail.
Yes.
All right.
Yes.
Thank you.
Mr. Krantz, without it.
The judge conducted a colloquy with Mr. Krantz to establish his understanding of bond conditions and prior experience with the bail system, confirming he knew violations could result in reincarceration. Under Tennessee Code Annotated Section 40-11-118, courts possess broad discretion to impose reasonable conditions on bail bonds to ensure defendant appearance and community safety. These conditions may include electronic monitoring, no-contact orders, and financial obligations. The statute further provides in Section 40-11-130 that violation of any bond condition constitutes grounds for revocation and return to custody, reflecting the principle that pretrial release is a privilege contingent upon compliance rather than an unconditional right. Here, Krantz was released on a $30,000 bond with specific conditions including GPS monitoring, which carries monthly fees. His admission that he previously violated bond conditions and returned to jail demonstrates institutional familiarity with consequences. The judge's questioning establishes the record for potential revocation, documenting that Krantz understood his obligations yet allegedly failed to maintain payments and committed new offenses while released. Bond revocation hearings serve as critical gatekeeping functions protecting both judicial integrity and public safety. When defendants violate release conditions, courts must balance rehabilitation opportunities against the demonstrated risk of reoffending, with GPS monitoring violations particularly significant as they directly impair the court's ability to supervise dangerous defendants.
Asking you the details, you were arrested in this case, if I understand correctly, on September 8th of 2024 for
Yes.
Aggravated domestic assault.
Yes.
And you made mention that you were on an OR bond, but the file here
Oh.
says you made a $30,000 bond through Pardue Bonding Company.
Yes, sir.
Right. And
February was the OR
That-
bond.
as of September the 8th of 2024, the bond conditions were that you must wear the GPS monitor. And that's since September the 8th of
Yes.
2024,
Yes, sir.
you were
Yes, sir.
supposed to do that. All right. And then I have another indictment, and I'm not asking you about the details, but it is true, is it not, that you were charged in a separate case with committing crimes of theft on or about the possession of a stolen motorcycle, and that is alleged to have occurred on January the 8th of 2025.
Yes, sir.
And that's still pending.
As far as I know, yes, sir.
Anything else
No,
you wish to be heard at argument?
I'll leave it up to the court.
The prosecutor established the procedural history. Krantz's September 2024 arrest for aggravated domestic assault, his $30,000 secured bond through a bonding company, and his subsequent January 2025 arrest on new theft charges while that bond remained active. In the 1992 case of State v. Brown, the Tennessee Supreme Court emphasized that bail serves dual purposes, ensuring defendant appearance and protecting community welfare, with conditions tailored to the specific risks presented. Under Tennessee Rule of Criminal Procedure 46, bond conditions must be necessary and appropriate to these ends. The aggravated domestic assault charge here triggered heightened scrutiny. Tennessee's domestic violence statutes under Section 391311L8 elevate simple assault to aggravated status when involving strangulation or deadly weapons, reflecting legislative recognition of lethality risks in intimate partner violence. The prosecutor's methodical chronology highlights two distinct bond violations: technical non-compliance with GPS monitoring and substantive new criminal conduct. The January 2025 theft arrest, occurring while Krantz remained on bond for the domestic assault, demonstrates the precise scenario bond conditions aim to prevent: continued criminal activity during pretrial release. The defense attorney's decision to defer argument suggests recognition of challenging facts. New criminal charges during pretrial release represent the most serious bond violation category, as they provide objective evidence that release conditions failed to deter criminal conduct. Courts increasingly view such violations as predictive of future dangerousness, making revocation more likely and reinforcing why thorough initial risk assessment matters for judicial decision-making.
Briefly, Your Honor, it doesn't surprise me that an individual that has the public defender's office has struggles with financial issues. It's pretty much the common theme of each individual I represent. I am familiar with Mr. Krantz's situation somewhat through our discussions as far as, the house situation. I'm aware of what he does for a living as far as doing mechanic work, and they're kind of being, somewhat seasonal kind of work. It's hard to do mobile mechanic in when it's freezing. I think that his history shows that there was an effort being made. I think that he was legitimately doing the best he could. He has stated that he has a chunk that he can get caught back up to where he, by my estimate, $600 or $700 short from fully caught up. We would just like maybe some time to make some arrangements for that and allow Mr. Krantz to stay out on bond so he's able to assist me in his case.
Your Honor, we heard testimony from Ms. Anderson. There's been multiple attempts to try to bring the account current. If Mr. Krantz had the ability to pay that money, he would have paid it by this time. This is kind of the last resort when it comes to payments, as well as Mr. Krantz understands the conditions of being on bond, and if you're unable to meet a condition of bond, it is likely that you would return to jail. He has been arrested on new charges. He has also, we've had issues getting in contact with him on this motion. I believe this is the third setting, so I would be concerned he's not keeping good contact with the courts and his attorney, which is also a condition of bond. Therefore, I would say that he has violated his bond in that he is unable to maintain this monitor. He's been given multiple efforts to be outside and on bail pending the resolution of his case, and he has failed multiple times.
The defense attorney argued financial hardship prevented GPS payment compliance, while the prosecutor countered that multiple payment opportunities were exhausted, new charges were committed, and Krantz failed to maintain attorney contact across 3 hearing settings. Under Bearden v. Georgia, 1983, the United States Supreme Court held that indigent defendants cannot be incarcerated solely for inability to pay fines or fees, requiring courts to consider alternative measures before revocation. However, this constitutional protection does not extend to willful non-payment or situations where other bond violations coexist. Tennessee courts apply this framework through State v. Cothran, 2016, which requires judges to distinguish between inability and unwillingness to comply with financial conditions, examining employment history, payment efforts, and available resources. The defense's seasonal work argument invokes Bearden protections, suggesting weather-dependent mechanic income genuinely impeded payment. Yet the prosecutor's rebuttal, documenting multiple failed payment attempts, new criminal conduct, and communication failures, transforms the analysis from pure indigency into pattern of noncompliance territory. The third setting detail proves particularly damaging, showing systemic disregard for judicial process beyond mere financial constraint. This exchange illustrates the tension between constitutional protections for poor defendants and legitimate public safety concerns. Courts must avoid punishing poverty while maintaining conditional release integrity, When non-payment coincides with new crimes and procedural non-cooperation, the balance typically shifts toward revocation, demonstrating how cumulative violations undermine even sympathetic individual circumstances.
I think it's important to be aware of the fact that GPS monitoring devices are not required in every case where a person is makes bond. So the reason why, and this court was inquiring into the court file as to why it was necessary to impose the GPS monitoring device. And I find the following was set forth in the affidavit of complaint that originated in this case back on May the 31st of 2024. On that date, it states that on September the 8th, 2024, at 15:33 hours, I, Deputy Sutton, was dispatched to twice daily on Jackson Phelps in reference to an possible attempted murder. On arrival, contact was made with the victim, Alexandria Smith. She stated that prior to calling dispatch, she was at 1001 Carl Perry Road behind the residence, arguing with her ex-boyfriend, the defendant, Jonathan Krantz, about her owing him $800 and stealing his phone. Victim stated that while they were arguing, the defendant had what was described as a black AR-15 style weapon in his hand. She stated that she sat down on the ground and began crying due to fear of being hurt by the defendant, advising that he had hit her with the gun in the past. The victim stated that while she was sitting on the ground, the defendant shot the firearm into the ground near where she was sitting. She stated her eyes were closed from crying when he shot and was unsure how close the round came to her. She described her right ear hurting after the shot. And that was the offense that led to the domestic aggravated assault charge being brought. On September the 8th of 2024, when he was arrested, the bond was set at $30,000 with a hand notation by the judicial commissioner, must wear a GPS monitor.
The judge independently reviewed the charging affidavit to explain why GPS monitoring was initially imposed. Reading the detailed allegations of Krantz firing an AR-15 near his ex-girlfriend during a domestic dispute, including her fear from prior assaults with the same weapon. Under Tennessee Code Annotated Section 39-13-111, aggravated domestic assault requires causing bodily injury with a deadly weapon or strangulation, carrying enhanced penalties reflecting the legislature's recognition of intimate partner violence lethality. The statute's sentencing provisions, combined with Section 40-11-118's discretionary bond conditions, authorize GPS monitoring when defendants present flight risks or ongoing danger to victims. Federal studies incorporated into Tennessee's domestic violence protocols demonstrate that firearm presence in domestic disputes increases homicide risk by 500%, justifying intensive pretrial supervision. The judicial commissioner's handwritten must-wear GPS monitor notation responded directly to these allegations. A defendant with history of hitting his partner with a firearm, who fired that weapon during an argument, presents precisely the combination of lethality and unpredictability that GPS monitoring targets. The judge's independent file review emphasizes that this was not routine condition imposition but tailored response to specific violent conduct, making subsequent non-compliance particularly consequential. Judicial explanation of original condition rationale serves appellate record development and demonstrates procedural fairness. When revocation rests on violation of conditions initially imposed for compelling public safety reasons, courts strengthen their determinations by articulating the original risk assessment here, that a man who shoots near his partner during arguments requires location monitoring to protect that partner and community.
That bond was made by Purdue Bonding Company, and it was also indicated that he would be required to adhere to the GPS monitoring devices as well. In the file, there was a prior instance of him having his motion in General Sessions Court, a motion being filed to revoke his bond. In the General Sessions, they sought to revoke his bond because he was out on a bond for aggravated domestic assault and that he had been arrested for tampering with his GPS monitoring by removing said device from his ankle. And they sought his bond to be revoked at that point. Obviously, I assume that didn't result in a revocation. But more importantly than his non-payment of those offenses, which certainly clearly violates the requirement of the GPS monitoring device, is the fact that on or about January the 8th of 2025, while he was on bond for this case, he was arrested and charged with possession of stolen property, a motorcycle. And that case is still pending. He has a 2-count indictment charging him with 2 counts of theft of property. One was a black 2022 black QLC G50Z trailer, the other being a 2024 BMW S1R. And reading the affidavit, it does indicate that that he was found to be in possession of those vehicles. Pardon me. It came back stolen. Mr. Krantz, when those vehicles were checked, Mr. Krantz was in possession of the motorcycle. He admitted to borrowing.
The judge revealed Krantz's prior GPS tampering attempt in General Sessions Court, removing the monitoring device from his ankle before emphasizing that new theft charges while on bond outweigh mere payment failures in the revocation analysis. Under Tennessee Code Annotated Section 39-14601, tampering with an electronic monitoring device constitutes a separate Class A misdemeanor, reflecting legislative intent to protect judicial supervision mechanisms. The new crimes while on bond doctrine, articulated in State v. Mallard, 2009, establishes that such conduct creates irrebuttable presumption of dangerousness for bond purposes, as defendants who commit offenses during pretrial release demonstrate that conditions insufficiently deter criminal behavior. Tennessee's bail reform statutes under Public Chapter 562, 2L22 further mandate that courts consider any new criminal charges as primary revocation factors. Krantz's documented pattern GPS removal attempt, payment default, and new theft charges demonstrates escalating noncompliance. The judge's explicit prioritization of new criminal charges over financial violations reflects proper legal hierarchy. While Bearden protects indigent defendants from incarceration for poverty, no constitutional or statutory protection shields defendants who exploit release freedom to commit additional crimes. The motorcycle possession, admitted by Krantz through his borrowing explanation, provides objective evidence of ongoing criminal conduct. This judicial reasoning illustrates how courts synthesize multiple violation types into coherent revocation determinations. The GPS tampering history undermines any claim that payment failures represented isolated good faith difficulties. Combined with new felony charges, it establishes that Krantz treats pretrial release as opportunity rather than obligation. For viewers, this demonstrates why bond conditions exist, not to punish defendants, but to test whether they can comport with legal expectations before trial adjudication. The court revoked Jonathan Krantz's bond and ordered him returned to custody pending resolution of both the aggravated domestic assault and theft charges. The judge's ruling emphasized that GPS monitoring was initially imposed due to specific lethality risks, Krantz's history of assaulting his partner with a firearm and firing that weapon during arguments, and that his subsequent pattern of non-compliance, including device tampering, payment default, and new criminal charges while released, demonstrated that no conditions could reasonably assure community safety or court appearance. Krantz was remanded to the custody of the sheriff for transport to the county detention facility, with his cases set for future trial scheduling. This proceeding illuminates the conditional nature of pretrial liberty in American criminal justice. The Sixth Amendment guarantees speedy trial rights, but no constitutional provision guarantees pretrial release. United States v. Salerno, 11987, upheld preventive detention for dangerous defendants without violating due process. Tennessee's system, like most states, operates on a spectrum. Own recognized release for low-risk defendants, financial bonds creating economic incentives for appearance, and increasingly GPS monitoring and other supervision technologies for those presenting elevated risks. The Krantz case demonstrates how this system fails when defendants exploit its flexibility. His initial $30,000 bond, secured through a bonding company, should have created financial and third-party incentives for compliance. Instead, he allegedly removed his monitor, ignored payment obligations, and committed new felonies. Such patterns force courts toward incarceration not as punishment. He remains presumptively innocent of the underlying charges, but as necessary protection when conditional release proves unworkable. For students of criminal procedure, this case highlights the tension between individual liberty interests and collective safety that pervades bail jurisprudence. The judge's careful documentation of original condition rationale, prior violation history, and specific new criminal conduct provides a model for defensible revocation decisions. It also reveals how technological monitoring, while expanding supervision capacity, cannot overcome defendant determination to evade accountability, a reminder that legal mechanisms ultimately depend on human compliance to function as intended. Consider how bond systems in your jurisdiction balance release and safety. Research whether your state uses risk assessment instruments, what alternatives to cash bail exist, and how courts handle indigent defendants who cannot pay monitoring fees. The Krantz case invites critical examination. When financial hardship and new criminal conduct coexist, what factors should predominate in detention decisions? Share your analysis and explore local court records to observe these determinations in practice.